And we're back with definitions for dummies. Why? Because some of y'all out here be using words incorrectly. On today's episode, we're going over some legal terms that you think you might understand, but don't. Or maybe you just never even heard of them. Now, I'm not a lawyer, but my mom used to be one. Plus, I know how to read and just like looking up definitions. Starting off with one of my favorites, jury nullification. The official definition is when a jury decides to acquit a defendant, even if there's solid evidence they committed the crime, because they believe the law or its application is unjust. Let's say someone pew-pews a CEO, hypothetically, and the state presents video evidence, witnesses, and a manifesto found on the accused. Sounds like an open-shut case, right? But the jury looks at the situation and thinks, honestly, they kind of had it coming. And they vote not guilty anyway. That's jury nullification. Basically, it's when the jury says, yeah, sure, they broke the law, but we're not sending them to jail for it. It's rare and controversial and totally legal, making it one of the most fascinating loopholes in the justice system. Next, let's tackle a big one, double jeopardy. I know you've probably heard this word thrown around in the crime shows or the legal dramas, but let's break down what it really means. The official definition is that you cannot be tried twice for the same crime in the same legal system after being acquitted or convicted. Sounds simple, right? But here's where it gets tricky. It doesn't apply when both state and federal governments want a piece of you. Let's say Luigi is charged by the state for committing a particular crime and is found not guilty. Great. But then the FBI rolls in with their own set of charges for the same act under federal law. Is that double jeopardy? Nope. Separate legal systems. It's called the dual sovereignty doctrine, and it lets state and federal systems prosecute separately. So the next time someone yells or asks double jeopardy about Luigi's case, you can tell them it's frustrating, but technically legal. Now we get into something a little more unsettling. Police deception. Now, the official definition isn't written into law, but court rulings have established that police are legally allowed to lie during investigations when gathering evidence or confessions, and this includes lying to the public. Remember when the police initially said that it was an expert pew-pewing and that no fingerprints had been found, and then suddenly fingerprints magically appeared? Or how they claimed the backpack was full of Monopoly money and dumped in Central Park that same morning, but when they picked him up and arrested him in Philly at McDonald's, he had the backpack on him, and it was conveniently full of all the evidence they could ever need? Yes, police deception is legal, but it's also why you should always question what you hear in public statements and never talk without a lawyer. Deception might be their tool, but protecting yourself is yours. Also note that police deception does not extend to their courtroom testimony. They are expected and must tell the truth when under oath. All right, now let's break down standard of proof. Standard of proof is the level of certainty and evidence needed to prove a case in court. So basically, it's the bar you have to clear to convince a judge or a jury. In criminal cases, the standard is beyond reasonable doubt, meaning there can't be any logical reason to question the defendant's guilt. In civil cases, the standard is lower. They only require a preponderance of the evidence, which means that it's more likely than not that something happened. Take the case against Luigi. The police presented video footage claiming it was him, but the video shows the individual wearing a completely different jacket and backpack than Luigi was seen wearing that day. Not to mention, the timing doesn't add up. It seems very unlikely he could have crossed town fast enough to match the timeline of the incident. These inconsistencies could be considered as falling short of the beyond reasonable doubt standard and result in a jury rendering a not guilty verdict. When the stakes are this high, the standard of proof is everything. If the prosecution can't meet it, the case should crumble. Lastly, we have circumstantial evidence. The official definition is evidence that relies on an inference to connect it to a fact, rather than directly proving the fact itself. So basically, it's when something suggests you did something without directly proving you did it. Think of it like hearing footsteps outside of your door and assuming someone's there, even though you haven't seen them. Imagine, if you will, someone disappears a few weeks before a major pew-pew incident. And then later, people start to dig up their online activity and find that they've been active in certain forums, or they've been searching or discussing questionable topics. There's no conclusive evidence tying them directly to the scene, no clear and distinguishable video footage, no clear full prints, but prosecutors will say, hey, look at all these clues. They add up. Circumstantial evidence is about connecting the dots, but it is not the same as direct proof. It can make someone look guilty in court, even when reasonable doubt's still left on the table. And that wraps up today's episode of Definition for Dummies. Keep questioning, keep learning, and remember, words matter, so use them wisely.